Good morning. Welcome to the First Appellate District. We have 3 cases on our calendar to be argued this morning. Counsel, when I call your case, please stand, state your name, the party you represent, and your readiness to proceed. The first case this morning is C-24-0702, State of Ohio versus Oliver.
Josh Thompson on behalf of Ms. Oliver, ready to proceed.
Victoria Lowry for the City of Cincinnati, ready.
Great, thank you. The next case is C-24-0566, Enri J.W.
Michelle Stagnaro for appellant, ready to proceed.
Dwayne Sims on behalf of Kelly, Mr. White.
Thank you very much. And the third case is C-24-0655, Kelly versus Forrest Holdco.
Aaron Mayrod for the appellant Forrest Holdco.
Great, thank you.
Ready to proceed.
Thank you. All right, we will begin with C-24-0702, State of Ohio versus Tasha Oliver. Mr. Thompson, you may come forward. Would you like to reserve time for rebuttal?
5 minutes, Your Honor.
All right, you may proceed when you're ready.
May it please the court, counsel. This case is ultimately about questions of fact and credibility. I just want to make a few key points about this case to focus on. We have this incident that takes place between Miss Oliver's truck and Mr. Barksdale's Honda Civic car. And a point of importance is that both say that this collision took place past the intersection. So it didn't happen in the intersection, it happened on the road beyond the intersection. The reason that that's important is that Miss Oliver, her truck is on the left and Mr. Barksdale's truck is on the right. And the right lane is the one that ends. We know that that's the way it was because that's the way they said it was, and that's where the damage is on her car, is on the passenger side. Now, they also agreed that that's where the collision occurred. So the reason additionally that that's important is that this means Miss Oliver, in order to hit Mr. Barksdale multiple times, as he
Counsel,
claims.
is it your position that the trial court based its verdict on the initial collision or on the subsequent behavior related to the firearm?
The subsequent behavior related to the firearm.
So is it material in any way that there was a dispute between the witnesses as to who initiated the collision?
Yes, when there's a question of credibility, we need to look at everything they said.
Were there facts to support the conclusion that Ms. Oliver was, I'll use the term, waving a gun around in the car?
I would say that there's evidence to the contrary,
Was there evidence to support that, though?
that Mr. Barksdale said it happened.
Okay. And she said she had a gun, right?
Yes,
And she said something to the effect of, you're lucky it's not loaded, right?
she said she wished she had it loaded,
She
yes.
wished she had it loaded, you're right. And so there were facts to support the conclusion that she was brandishing a firearm, right?
There were, but they
Okay.
weren't credible facts.
Well, we have to defer to the fact finder, don't we?
Well, not when the fact finder abuses its discretion and when it finds facts that are impossible.
Okay. Can you explain what facts are impossible in this scenario?
So that goes back to the left and right scenario. Miss Barksdale would be on the driver's side, and there would be a passenger side in this truck in between the two of them. That means in order for her to hang out and point a gun, she's got to be driving and leaning out this window and pointing a gun at Mr. Barksdale. This
Is that something that the trial court specifically found? I seem to recall there was discussion about the firearm being like above the steering wheel or something to that effect?
Mrs. Oliver's testimony and the finding was that she was holding the gun on the steering wheel. But I think that what's critical about that is the allegation and the complaint, and the thing that Mr. Barksdale said caused him fear was the gun being pointed at him.
And so is it your position that that the conviction rests upon a factual determination that the gun was out the window rather than on the steering wheel?
I at least pointed at him.
And could it have been pointed at him on the steering wheel?
Not in the way that he said that it happened. And if she's holding it on a steering wheel, I would assume it was pointing upward.
Is that okay?
Well, I don't think it's relevant. I do obviously understand the question coming, being that there are many ways to commit an aggravated menacing. And
Well, I guess my question was more towards this issue of credibility that you talked about. Isn't it, doesn't that make it more credible that someone who would hold a gun on a steering wheel while driving is also capable of pointing a gun out the window at another driver? Making
least-
that version of the facts more believable.
at least to the extent that a gun was in her hand, yes.
Okay.
I don't know that it would make her more likely to point it, but it makes her capable in the fact that the gun was in her hand of doing it.
Okay, and you had talked about it being incredible, so I'm still confused as to what is incredible about the version of facts that were found below.
Well, I think we have to look at the totality of everything that took place. I already pointed out the hanging out the window. We had the independent witness, Miss Maley, said that Miss Oliver threw things out the car. Mr. Barksdale never made that allegation. Mr. Barksdale makes this allegation that Mrs. Oliver said unkind things about him and his baby, but he also said her baby, or his baby, was in the back seat on the passenger side, which somehow means from the left lane in the driver's seat in a truck, Miss Oliver was capable of seeing this baby and mentioning it, and for some reason is angry enough about this situation to threaten a baby. She had to be willing to wreck her brand-new truck that she cared about. Doesn't make a lot of sense to do that over this minor traffic disagreement.
Ultimately, part of your argument hinges on that the only evidence of the pointing of the gun comes from the victim. Is that right?
Yes.
Okay. And then it begins with the actual collision, and as I'm understanding, you're saying that based on the photos of the damage to the vehicles, that it is an impossibility for the collision to have occurred the way the victim had articulated, and that it supports how your client has articulated, right?
Correct.
So here's my question based on that. So are you saying that the photos are so obvious on their face that it doesn't require anything more than a layman to be able to look at them and make a determination as to what caused the vehicle and what driver caused the vehicle?
That's exactly what I'm saying.
The crash. Okay.
And that it's certainly not consistent with 3 ramming incidents.
Yeah, because I noticed that there wasn't anything further admitted into the record with regard to the collision.
Correct.
I mean, there was testimonial evidence, there was the photos, but nothing further than that.
Right. Nothing of Mr. Barksdale's car,
Okay.
for instance.
Because that's where I'm trying to understand if you're asking us to step into like the experts, you know.
Not an
Do the
expert
shoes of an
role,
expert or, yeah.
Just I mean, I think that's kind of the crux of a manifest weight argument, is that it really needs to be obviously wrong, and that's what I'm saying here, is that it's obviously wrong.
Can you address the third-party witness? I mean, how does that play into the calculus that there was another person who observed this interaction who, at least on their face, was unrelated to these two people?
I think essentially that she saw something happened and filled in the blanks after speaking with Mr. Barksdale, because she stopped with him. I think it makes no sense that if she's behind the entire time, that she's able to identify Mrs. Oliver in court. How does she?
So is your perspective that they essentially colluded prior to speaking with the police?
Collusion would imply some sort of malice.
Well, that they got
Yeah.
their stories, their stories were in common before they spoke with the police?
I think that they were influencing, I'll put it that way. I can't go so far as to say anything nefarious took place.
Does the record support that? Does the record suggest that the two of them spoke on the scene before the officers arrived?
That's my recollection, but if I'm wrong, I thought that they stopped further up the road and saw Miss Oliver do a U-turn. I thought that I recalled them speaking. If I'm wrong, then I'm wrong, and I apologize for that. The other thing about Mrs. Maley is she said the whole thing took about 10 minutes, and we know the 911 call was about 6 minutes, 43 seconds, and we know that Miss Oliver said it took 40 seconds to a minute for her to call 911 after the accident. So my point there is that we have essentially a similar time frame to what actually took place, 8 minutes, 10 minutes, something like that. And we heard everything that Miss Oliver said on that 911 call. And there was no threat to kill Mr. Barksdale.
So I wish this thing was loaded, or I'm not quoting it exactly, but that didn't constitute a threat?
That I wish it was loaded?
Correct.
It's not the threat that Mr. Barksdale relied upon. His evidence was he was scared from having the gun pointed at him.
Okay.
I'll reserve the remainder of my time.
Thank you very much.
May it please the court. It's a privilege to be here in front of you this morning. Before I get started in any actual argument, I want to apologize that there are several typos in my brief, and including one substantive error that I actually just recognized this morning, is that I indicate to you that I'm giving you 3 first district cases, all with convictions for aggravated menacing, the first of which, State v. Bingham, was not a conviction of aggravated menacing. It was a conviction for menacing, the lesser included of an aggravated menacing. So I wanted to correct that on the air and apologize for that.
Counsel, can you address for me this issue of impossibility that was raised by the appellant, that this is just an incredible set of facts and not possible that anything
Yes.
like this could have occurred?
Yes, thank you. Well, let me first say, it's interesting that defense concedes right out the gate that this is a question of fact and credibility. Because with this manifest weight argument, as you know, the law provides that you will defer to the fact finding unless it is so incredible, and that there's a manifest injustice because of the incredibility of the fact finding by the fact finder. In this case, I don't think it is incredible at all. This case is supported by not only credible testimony of the victim, Mr. Barksdale, but it's supported by an independent witness, Ms. Maley, and I'll get to a question that you'd posed to defense as to Ms. Maley in a minute, but it's supported by that as well. In fact, after the case in chief, the defense put on Ms. Oliver herself, so her testimony, and then the 911 call. The 911 call is so telling. I mean, if you just hear the 911 call alone, it's not incredible. Ms. Oliver is angry when she calls 911. She's angry, where are the police? Why aren't they here right now? As though they would appear like that because she made the phone call. She's angry at the person who's yelling. You can hear this yelling going on back and forth. And she says on the 911 call, I wish this MF was loaded. She says it in an angry tone.
Sure, but
Those things aren't incredible.
My understanding of the argument is that it would have been physically impossible for her to, in the driver's seat, reach over across the passenger seat and extend her arm out the passenger window while driving. That despite her anger and everything else, it was just physically impossible for her reach to extend that far.
Without knowing exactly where I'd find it in the transcripts, I believe that the facts are a little bit different than that. I believe that the facts start at the intersection where there's a left turn lane and a couple straight lanes, one of which is going to disappear into the other up ahead. and there's almost a collision there where Ms. Oliver is on the left of the two cars. So as you would indicate, Mr. Barksdale's out her passenger window at that point. But as the story goes, and everyone's testimony, I think, agrees, that the cars travel up the road, impacting each other for whatever reason. And I would say it's because Ms. Oliver is crashing into Mr. Barksdale's car, her big truck into his car, as he testified, and Ms. Mela testified. But then they get up the roadway, and Ms. Oliver has switched sides. She's over to the right. And although it's not exactly clear when everything happens, it's all sort of flooding together, she is on the right at some point, and she has at least a gun in her hand on the steering wheel, as she concedes. She admits to the court, but she could very well, it wasn't explained which hand had it out, but that his testimony, Barksdale's testimony, was that he's over here at this point. He's on the left of her at this point, and she's pulled up to the right of him. They're sort of catty corner. That's what I remember from the testimony as I read it in the transcript. So at that point, she could very well have put it out the window. And the testimony of Ms. Maley is that she's throwing things out the window from the position on the right, maybe a white cup or something that Ms. Maley didn't know for sure what was being thrown, but she could hear yelling, she could hear a baby. Ms. Maley was never asked, and she never testified that she saw a gun, but Barksdale was very clear that he saw a gun, that he knew what a gun looked like, that he was afraid he was going to get shot, and the baby in the back seat. There was very little mention of a third person that was in the car. There was an adult woman in the car, in the passenger front seat during all of this. They didn't talk a lot about her, but that's my understanding.
Counsel, it seems clear, and I believe in your brief you somewhat conceded that the testimony of the three individuals who were there that day does not perfectly line up with each other. However, is it necessary for the trial court to resolve all of these factual inconsistencies to reach the verdict that it reached? In other words, does the trial court need to believe the victim or the other driver that Miss Oliver was reaching the gun out the right-hand side in order to reach a verdict of guilty in this case?
No. So the trial court is free to believe whatever of all of the testimony and all of the evidence and weigh it at its discretion. It's only when they weigh it so impossibly or that the evidence really wasn't leaning that way, right, that you would want to overturn it. In this case, yes, I can see that they all have different scenarios. But what we do have is Ms. Oliver agrees that she's in the city of Cincinnati driving up the road, and there's a car crash, and there's an argument and an altercation, and that during that time she pulled out her gun, which she keeps in her console for times like this. And although she doesn't agree, she pointed it at him or said, "I'm going to shoot you," she does agree that she displayed it in a threatening way and was yelling threatening things out the window to him, and we even can hear her doing it on the 911 call. So if the court weighs all of that and says, that's enough to convict, it doesn't necessarily mean that it knew for sure exactly whose car impacted whose, or exactly what part of the roadway they were when all these things were happening, because it's all happening, like I say, flooding up. And if the court just makes enough sense of it that it's beyond a reasonable doubt, then their guilty finding should stand, even though there's some things that are not reconciled.
Is resolution of who caused the car crash critical to the issues in this case?
Well, Your Honor, in a typical accident car crash, I think it would not matter. I mean, because it's a car crash, and if people get angry after an accidental car crash, that's a different story. But I don't think that's what's going on here. I think that the testimony is clear from at least two of the parties one who is a disinterested party who got interested because it was such an extraordinary sight in front of her as she went up the roadway, who expressed concern for Mr. Barksdale, not concern for Ms. Oliver, went with Mr. Barksdale, didn't follow Ms. Oliver. I've lost track of the question.
Is it
I'm sorry.
significant to be able to understand the positioning of the vehicles?
Thank you. So I think it's important to know that they were positioned in one way and another, because the people who are saying they saw what they saw had to have been in a position to see it. And as Judge Moore pointed out, was it out the passenger window? Is that an impossibility, or was it out the driver's window?
Because I heard you say earlier that it seemed as if the vehicles had changed positions after the collision.
Yes.
Okay, so as I understand the threat, it didn't occur at the moment of the collision. It would have occurred sometime after the collision, right?
Well, that's maybe, thank you, because you're actually getting me back on track to this question. So
Okay.
is this a car
It's all
accident, or is this
interrelated.
aggressive, threatening behavior by crashing a truck into a little Honda or a little smaller car? So I think that the testimony and the evidence could show that, does show that, as Mr. Barksdale said, they were at an intersection where they almost collided. And then after they proceeded through the intersection, she was intentionally hitting him, that he believed that she was intentionally dragging him up the roadway aggressively with her foot on the gas as she was already dragging him impacted. She didn't accidentally bump him, he didn't accidentally bump her, and then it stopped. She drove and drove and drove. He testified that he was being dragged up the roadway, that the sound of her wheels was out his driver window, freaking him out, and that the people in his car were. So that, to me, isn't just an accident.
Didn't the trial court find his version of events more credible because it was largely consistent with the third-party witness?
The court did say that in its finding, that the corroboration of Ms. Maley with Mr. Barksdale, at least as far as she saw and what she knew, was one of the reasons. But the court also said that just what Ms. Oliver conceded alone was enough, that taking your gun out of your console and displaying it along your driver's wheel in a threatening manner, which we know it was because she was yelling and cussing and swearing at them and calling them names, the people, you could hear it coming out of her on the 911 call. The court said that that was enough and that she was guilty of aggravated menacing, that alone. But
What about having the gun on the steering wheel in and of itself? Nothing, no yelling, no screaming, just cruising down the road with the gun on the steering wheel. Is that problematic? Is that illegal?
I would rather not say what I know about whether it's illegal or not, but let me tell you what the court talked about and said that she weighed that. She weighed in her own assessment of the facts that people have a legal right to carry a gun. That in Ohio, we have the right not only to concealed carry, but open carry.
No, I understand that, but I'm speaking of this particular set of facts where the individual is holding the gun on the steering wheel while they're driving. Is that legal?
In any set of facts, I don't want to say that I know that every time a person holds their gun up here while they just drive down the highway would be illegal. I don't want to say that. But in this case, we have a lot more facts than just that.
So there are some situations, there's a scenario that you can envision where someone can drive down the road with the gun on the steering wheel while they're driving.
I don't want to say that I know enough about the law to say that that's illegal. I think it ought to be.
Okay, thank you.
I'm still trying to wrap my mind around a couple things, and I'm going to ask you to help me, okay?
Please.
As I understand, counsel, defense counsel, there's two things that are kind of standing out to me. One is that the collision could not have occurred the way that the trial court ultimately determined that it had occurred, because the photographic evidence is plainly inconsistent with that. And that then bleeds over to a question of credibility on statements of the victim and also of the third-party witness. And then the other is that based on the position of the vehicles pursuant to, I think it's pursuant to how the victim articulates that the crash occurred, that it would have been an impossibility for the gun to be pointing out the window, which is what his testimony is. So maybe I should have broken those up into two questions, but,
I'll try
but
my
can you,
best to
if you can
answer.
address that, yes.
As to the photographic evidence in the description of the crash, I think.
Right, the first
actually-
question is that the argument that it's plainly inconsistent with the testimonial evidence.
I think it is not inconsistent. I think the testimony of Ms. Oliver and Mr. Barksdale, plus the photographic evidence, is that the crash occurred with Ms. Oliver on the left of the two cars proceeding up the hill.
So let's say, just for argument's sake, that we were to determine that it is plainly inconsistent. Is that outcome determinative?
No, it is not. Although it would weigh against the credibility as to that fact and the speakers who would contrast what you might believe about the fact.
Because let's say, again, if it's plainly inconsistent, then we still have to get to the testimony of the firearm, right?
Right. I mean, so the firearm is where we get to aggravated, because that has the ability to cause
Right.
serious physical
Yeah.
harm.
I mean, the charging was all based on the firearm, not on the accident.
Right, but the totality of the circumstances for the fact finder to understand the whole big picture is that if someone is aggressively crashing into your vehicle while yelling at you and cussing at you and chasing you up a hill, that is all threatening behavior in
Correct.
itself.
Correct. So the second question has to do with, as I understood the argument, that it was a impossibility based on, I believe it's based on the victim's testimony, that the firearm would be out the window.
And
And that was the sole evidence about the menacing behavior to which the charge is based on.
I don't find that it's impossible. I think a lot of things are possible.
So can you explain why it's not impossible? That's what
Well,
would help me.
as the cars were crashing, I don't think that's when it was testified to that the gun was displayed. I believe that the gun was displayed up the road after the crash, when the cars came back together momentarily until they both went off in their own directions. Seems that that was when the 911 call was made, during which we could hear her talking about the very gun that she admits was in her hand on the wheel. It was not impossible at that point, in that juncture, with windows open and cars aligned as they had switched sides, as Mr. Barksdale testified and Ms. Maley testified, that she could very well have done this or done this. I mean, physically, she could have used either hand.
So let me ask, at the moment that the firearm was used in a threatening manner, where were the two vehicles? Who was on the right and who was on the left?
My understanding from reading the transcript, so only that, is that Ms. Oliver was pulled over to the right at that point. And in fact, the cars stopped momentarily. So the impossibility of driving and talking on the phone and holding.
Didn't he say that they were stopped at a stop sign and she was in front of him and he was behind her? And that she leaned out of the window back at him, not side by side, and pointed the gun backwards towards him out the window? And couldn't that happen in the way
He
that
described it.
he described?
Yes, I agree with you. And I guess I pictured it more catty corner than like immediately behind, like he sort of described that he was to her left, but behind.
I mean, that's not impossible for people to stop at a stop sign and lean out the window, right?
Not impossible.
Okay.
And
Thank
in
you, and
fact-
you're
All right,
out of
thank
time.
Thank you very
Thank you.
much. Thank you.
First thing I want to point it out is just that page 58 onto page 59, Miss Maley, that's where she said Mr. Barksdale pulled over and so did she. So,
And then are you making an inference that they would have had a conversation at that point about what happened?
yes. Next
That's
thing.
understandable, isn't it? You have two people who witnessed what, at least according to what the trial court found, is absolute chaos. And wouldn't then that excitement, they would have some conversation about how unbelievable it was that someone would brandish a firearm going down the street following a traffic accident?
Yes, but
And
then
it-
that information about the firearm would have come from Mr. Barksdale solely.
Well, even if it did, that's still something that the trial court could have decided to believe, right?
Sure.
Okay. And am I correct that the punishment for this incident was $100 in costs and $42 in fees?
Yes,
There was no probation,
correct,
there was no loss of a driver's license?
correct.
She's still able to carry a firearm?
Mm-hmm.
Okay.
If the question is mootness,
No, it's not mootness. I'm
Okay.
just want to confirm that a $100 fine is what this kind of chaos would merit.
yes. I'd point out on page 32 and 33, Mr. Barksdale said he was able to squeeze like between a small gap between the front of her car, meaning Miss Oliver's car, and some parked cars, which I think is consistent with him being to the right. I did see what the state was talking about at the parking when they were at the stop sign and the, like, Miss Oliver being at the back corner. I see what you're talking about. But then Mr. Barksdale goes on to say that the gun was pointed when Miss Oliver was back out in front of him again. So I took that to mean that either, as I said, he had to point through the passenger seat or would have to be hanging out this way.
And Barksdale was subject to cross-examination at trial, so,
Yes,
and so all of those inconsistencies were able to be explored in front of the fact finder, is that right?
that's right. So, if there are no further questions, I just ask that the court find that this conviction was against the manifest weight of the evidence in reverse. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision.
Thank you, Your Honors.
Thank you. The next case is C-24-0566 in re JW. And as counsel is coming forward, I will remind you both to avoid saying the name of the minor child in this case.
Good morning.
Good morning. Would you like to reserve time for rebuttal?
Yes, 5 minutes, please.
All right, you may proceed when you're ready.
Thank you, Your Honors, and Mr. Sims. We're here today, I represent the mother in this action. It was a juvenile court action in Hamilton County regarding the modification of a joint custody, in our language, in Ohio language, a shared parenting plan. So I know that I laid out kind of the procedural history, but I think it's important just to kind of touch on a few things. First is, the parties had a child who was born in January of 2018. In 2019, they were living in Virginia, and there was an order put on for what's called a joint custody plan, which is they had joint decision-making. Mother had primary time, father had 1 weekend a month, and that was his parenting time schedule at the time. Mother moved to Ohio then in 2018. Father moved to Ohio but Athens in 2019. Mother filed to register that joint custody plan from Virginia in 2019. Once father moved to Athens, Ohio, he was still a time away. He was still only exercising approximately 1 month of parenting time, although he was not consistent with that time. He filed to modify the parenting time to include holidays, which was not addressed in the original Virginia order, and that was modified. So he didn't file to modify his parenting time, just the holiday schedule, and there was an agreement reached, and it was filed with the Ohio court in Hamilton County. Fast forward to 2022, father moved to the Cincinnati area in 2022. Mother then filed a motion to modify this joint custody plan from Virginia because she was having difficulty with father being consistent with his parenting time. Giving notice, it just did not make sense now that they were in the same city, and she filed to modify the plan to put a more consistent schedule in place for their son. In the meantime,
And counsel, am I correct in recalling that from the outset of that motion, she was seeking for him to have more time with the child?
That is correct, Your Honor, and had offered it. And there were a few times, especially during COVID, when schedules allow, father did have some extra time. It was never an equal time schedule. But when he moved to Cincinnati, she offered that he would have additional time, which he did not take her up on it. Through the course of litigation, there was a temporary schedule put in place that I think was being exercised, but not fully. So during the course of litigation, my client filed a proposed shared parenting plan that would comply with what Ohio requires in plans, which is a lot more comprehensive than what the Virginia order had. But ultimately asked the court to put in place the temporary parenting schedule, make that a permanent schedule for father, plus giving him all the rights and obligations as a co-parent.
And by this time, the child was in school, right?
At the time she filed, he was not. He was 4.5 when she filed. Ultimately, now he's 7.5, but ultimately this took a couple years to get finalized, so now he is of school age. She had enrolled him at Summit starting from preschool, so he had been at Summit and then continued there through kindergarten while the litigation was pending. So the issue really in this litigation is what dad's parenting time schedule should be. I don't think there was any dispute over the other items or other terms
Is
of
it
the
your
plan.
perspective that a change in circumstance was not required?
Absolutely. And again, if you look back at mother's motion, it's clearly a motion to modify the terms of their joint custody order. Although she filed, again, this proposed plan, that's because Ohio has certain rules, our courts have certain rules on what language has to be in there, but it still maintained the joint custody part of it, which is what the allocation is. So it's basically, she filed a motion to modify their shared parenting plan. So that means
The
that.
trial court actually determined that the parties were in agreement that there was a change of circumstances, and you have not contested that.
No, and I guess, even though we don't have to show a change, the change really was dad moving closer. So he wasn't 3 hours away, he was now, living closer. But, in terms of modifying the terms of a shared parenting plan, there's no requirement for a change in circumstance. All you have to show is that it's in the best interest of the child. It's 310904 E2B is the applicable code section. So.
And what factors, if any, do you think would govern the trial court's best interest determination in an E2B situation?
And that is a great question. So I know that this court has held that we don't have to apply the F1 factors specifically, although I think that would be guidance for the courts. I mean, we already have them listed out as what is considered best interest factors, but I think with a modification of parenting time or request for that, I think they could be guides, but they don't have to be the end-all be-all, which is required when there's an initial custody determination.
So it wasn't a mistake for the trial court in this case to look to the F1 factors?
Correct. What I found puzzling, though, is why they looked at the F2 factors, because the F2 factors deal specifically with whether shared parenting is in the best interest of the child, and that was not in question. There was no question that there was going to be a shared parenting plan. It was just, what should dad's parenting time schedule look like?
And so is it your perspective that it was a mistake to consider the F2 factors at all? Or is it your perspective that the trial court just misapplied some of these factors?
In my opinion, they just misapplied. I think for some reason, they kind of got lost in the statute as to what they were supposed to look at, instead of just focusing on what is in the best interest of this child. And there were pages of going over, again, change in circumstance and the shared parenting factors, which I don't think the court needed to do, and I think it kind of got lost in doing so and coming up with its schedule.
And then the trial court here also looked at the, I'm going to blank on the statute number, but the D factors on parenting time as well. So there were 3 sets of best interest factors that the trial court considered. Are you in agreement that the trial court could look at the D factors as well?
I do, and it's 3109051, which it normally is a situation where you've got a residential parent and a non-residential parent. But again, I think when the court is looking at this umbrella we call best interest, I think they could look to both best interest factors and sections. The D factors, they have a little more in them than they do under the F1 factors, but ultimately, they're pretty much the same. But I do think that the court can consider both, and I think this court, and I'm drawing a blank on the case recently that addressed that, even if it's a shared parenting situation, if we're talking about parenting time only, you can look at the D factors as well.
So drilling down into this argument then, where would it be that the trial court misapplied the F1, F2, or D factors in this case?
And I think then we get to the more fact-specific question. I mean, the reason for me bringing up this in my brief and in my argument is I think that the court needs to be clear what the rules are. And I don't think the court was clear what they were supposed to be doing and kind of got lost in that. But if we drill down to what the factors were, we believe that the court misapplied that for a couple reasons. So we have a situation where a father was largely spending time with a child 1 week in a month, if that. I mean, he really was inconsistent with his time. So we have that situation. And going from a 1 week in a month situation to then going to an equal time schedule in a pretty short period of time, especially with a young child, is something that I think the court should have considered more carefully. Not just that, but father had this time and he was choosing not to exercise it. So whether it's his weekend time or whether it's his holiday time that he specifically asked for, he just couldn't be bothered sometimes. I mean, he said that, if it didn't fit my schedule, then I wasn't going to do it. Just like when mother offered additional time to him and said, sorry, I can't do it because of my work schedule, even though on Wednesdays he wasn't working, according to his testimony. So he had this...
Counsel, can you help me understand how, because I understand the argument here to be that mom wanted a specific parenting time schedule that would have increased dad's parenting time, but would have fallen short of equal time. And so why would it be the case that dad's inconsistency would support an additional amount of parenting time under the plan mom wanted, but not support the equal time that the trial court imposed?
And that is a good question. I think you'll see from the testimony and the actions of mother throughout this child's life, as she really wanted dad to be a present dad, wanted him to be involved, wanted him to do all the things that are important for a co-parent, and she tried. She tried to do that with him. And I think that was this effort. And then the court had already put in place this temporary schedule, which I think was largely working, and that's why mother wanted to just incorporate that into a final order. Whether or not that would have continued, and certainly I can't comment on whether it has or not, but that's something we wanted to give him the opportunity to do that, to become more involved. Even the guardian ad litem testified, we want to give him that option, that ability to be more involved now that he's closer. Whether he chose to do it or not is another thing. Another part of the equal time schedule that is concerning, besides his consistency, is just not otherwise being involved in the day-to-day of the child, not going to doctor's appointments, not taking him to activities or taking him late to activities. These are all things, when you have that equal time, there is an additional burden on that parent to be a more involved parent. He may have to, attend a school function or an activity or a medical appointment, which he consistently not only didn't do, but didn't really want to do that. And so that was a concern for Mom. Another part about having an equal time schedule is having that open communication with the other co-parent, because you need to be able to say, okay, there's this stuff due at school, here's the homework.
Counsel, was there any evidence before the trial court that Dad did want to actively participate in the child's life and was making an effort to do so?
So up until the point that there was a temporary schedule, he wasn't. I think he tried to make a little bit of an effort, my understanding from the record, between the time of the magistrate's decision to the time of the judge's decision, where I think he went to 1 or 2 school activities, but then it dropped off again. So it was kind of like he was being prompted to do it because he heard that's what he had to do, but then when it really came down to it, he wasn't doing it. So, he had the ability during that period of time to make more of an effort like the GAL had requested and it testified to, and he did. I think the time period was between the first trial setting in October and the second trial setting in January. But between the time of the magistrate's decision and the judge's decision, again, he stopped participating.
Counsel, you're out of time.
Okay, thank you very much.
Good morning.
Morning.
Pleases the court. On behalf of Father, when I look through the brief in this case, it seems to me that the trial court got to the place where it was supposed to go. And I think they got there because they took a foreign order, which was from a different state, which by counsel's admission had some different standards than we apply here in Ohio. What the court did is looked at it from a more thorough and a more comprehensive manner to look out for what was best for the child. Mother is the one who asked for shared parenting in this case, and she proposed a plan that increased Father's time in spite of what the argument was this morning. In fact, it's pretty hard to be a very active parent with a child who's less than 4 years of age and you live in Virginia and the child lives here in Ohio. So to come here for doctor's appointments is kind of taking a stab at weaknesses because of the distance between the two. The next issue is that counsel argues because Father moved to Athens, they attempted to increase the time. Athens as well is 2 hours away from here where the child's primary activities were. However, Mother, when Father was able to move this jurisdiction or closer to it so that he could spend more quality time with the child, promoted it by filing her own plan. The twist that it appears that they're not liking is the fact that they had a third independent party, guardian ad litem, who is specifically trained by the courts, who actually goes through courses and is not a relative or involved in this case, but looks out for the child's best interest, made a recommendation to the court, ultimately, that the parents share equal time. The court adopted that plan, gave the parents equal time. But in the brief, the things that are being argued here don't really make a lot of sense in terms of looking out for the best interests of the child. Because the trial court, as the court is well aware, is given a broad latitude in custody cases because they have the hands-on dealing with the testimony, the circumstances, and everything that occurs in that particular hearing. In this case, coupled with the guardian ad litem's report, the testimony and evidence that they heard.
Counsel, am I remembering correctly that the guardian ad litem recommended that this be phased up to equal time?
And that's what occurred.
And the trial court put a plan together to increase
Yes.
time incrementally?
Yes. And that's what happened in this case. And I think as a result of taking those factors into consideration, we don't discriminate because one parent is the father and one parent is the mother. They're equal rights. They have an equal opportunity to parent and rear their child.
And speaking of that, how do you respond to the argument that dad did not fully participate in that right to participate in the child's life?
Well, again, Your Honor, we go back to the original proposition. If father lived in Virginia, mother lived in Ohio, the participation for the day-to-day activities for someone who lives 3 states away is not as simple as somebody who lives next door or lives in the same community like father does at this particular juncture. So that distance or that proximity issue has been remedied at this point, which allows father to have full participation with the child.
What about when dad moved to Athens and was closer?
He's still 2 hours away.
Right,
Which
but
is still problematic a lot of times for day-to-day activities. The 2 hours, let's assume they live 2 hours away. To come here is 2 hours, and it's another 2 hours to get back to Athens where his employment was. So you're talking about a 4-hour day that he would spend traveling, let alone
But
with-
was there any increase in his participation after he closed that distance? I recognize it's still 2 hours, but it's not as long.
There was some change because I believe it was father at that point that requested an increase for the holiday visitations. So at that juncture, there was an attempt to improve more. But father was realistic in terms of where the child was at the time and his ability with starting a new job. Because let's not forget that when he moved from Virginia to Athens, he transferred employment. So he was also starting a new job. So he did increase his time, and he continued to increase his time to the point where we're at now. The court had an opportunity to examine those factors, and it even looked at more factors. And at this particular juncture, I believe that the court was quite correct and established the opportunity for both parents to equally contribute to the child's rearing.
The GAL was complimentary of both parents, right?
Yes, yes. There were some of the same concerns about the earlier participation because of the distance, but obviously when the GAL did the interviews, they felt that father's capacity to interact with the child, provide suitable housing and the like was there, and just the opportunity for him to experience that and become more familiar on a day-to-day routine basis, that it was appropriate for him to have that expanded parenting time with the child.
Counsel, would you like to address the other assignment of errors?
Yes, Your Honor, I pretty much did it in the brief, but I would touch on them because I think in the brief, they talked about the father's testimony. Apparently, at some point in the trial, it appears that it was a continuation and father was called back to the witness stand for a second time. I don't see anything in the testimony that necessarily indicates that the testimony that he provided, either time was more significant than any ordinary
As
testimony.
I understood that, counsel, Dad was called as a witness by mom.
Correct.
As part of her case in chief.
As on cross,
On
yes.
cross-examination.
Yes.
That was part of her presentation of
Correct.
evidence. And then he was called as part of his
On
case in
direct.
chief on direct, as part of his presentation and evidence.
Correct.
Is there any problem with that order of presentation, where
Every-
each side can present their own witnesses?
Every trial that I have ever done on a custody case or any other case, you have an opportunity to call your own witnesses for each presentation of the case. Sometimes they're consolidated to avoid duplicity in testimony, and generally the hearing officer will request as to whether or not you wish to do both in the same setting. You don't have to, but it's an option in order to consolidate time that they sometimes allow you to do. In this case, obviously, that wasn't done. So I don't see a problem with testimony occurring on direct and cross-examination. I think that was appropriate.
What about this testimony regarding the domestic violence before the child was even born? What's that got to do with anything?
Well, I think that that's a factor that could be discussed because I think the court is well aware that domestic violence is one of the factors that the court is supposed to consider in doing a shared parenting plan. But obviously, based upon the fact that the shared parenting plan was granted, that testimony, although heard, was pretty much set on the wayside because it had no impact on the ultimate decision of the court. And I believe that judge, after the magistrate's decision was issued, remedied that by going forward with a shared parenting plan the way she did. So if there's no more questions, I just wanted to be simple, straight to the point, because I think the court was correct in this particular instance. Both parents have equal parenting time. The child appears to be doing well at this point. There's been no changes. There's been nothing new that's going on, so I believe that the court was correct in its decision. I hope this court will uphold it.
Thank you.
Is court satisfied with going through the assignments of error?
Thank you.
Thank you.
I mean, this is your only opportunity to do so, so I figured I'd
Okay, I
open the
appreciate
door for
that.
you.
Yeah, because I believe there was some question regarding evidence rules, and I believe that that was going to the domestic violence issue that we discussed, and I believe the testimony with the direct and cross-examination was addressed in this particular instance, and I believe there's no abuse of discretion because I think that the court did exactly what it was empowered to do below.
Thank you.
Thank you.
I first want to say that I disagree with Mr. Sims that things are going well, but since we cannot talk about that, I won't go in any further detail.
And why bring that up?
Because Mr. Sims was able to say that things are going well. So yeah, I feel that should not be considered by the court for any reason. With respect, I want to kind of talk back from my third assignment of error, which is about the testimony. This is, I think, a little bit of a unique situation. So what we had is my client's counsel calling Dad as if on cross-examination as part of the case. Father's counsel, instead of just allowing her client to sit down, chose to do direct testimony at that time. So she made the conscious choice to start questioning him and asking him all the questions during direct, and then she rested on that. When we came back to court in January, as part of her case, she recalled Dad, and there was an objection, and the trial court specifically said, I will allow you to update anything that's happened from October to January, which was the gap in between the court. Instead, it allowed Father the forum to go back into these domestic violence allegations, to add more detail, and which was completely inappropriate.
Was
Again,
there an additional objection lodged at that point that the testimony was going further than what the trial judge had determined would be the basis of the testimony?
yes, there was an objection and it was overruled. And the reason for it being overruled was because the magistrate said, well, I heard Mom testify about it, so I'm going to go ahead and let Dad testify about it again. The only reason Mom testified about it, and even the trial judge found this incorrect, by the way, she did not testify at the October hearing. She only testified in the January hearing. And the reason she even addressed those issues is because Dad was allowed to testify about the domestic violence in the October hearing. So it wasn't like she was bringing it up on her own. She was having to defend herself against something that should never have been allowed into evidence in the first place. And then he was allowed to go into it again, even though it shouldn't have been it wasn't part of the limited scope that the court allowed him to be recalled on direct.
Is the issue that Dad was permitted to testify in his case in chief, or is the issue with the information that he provided during that examination?
I mean, it's both. I think it's more of a procedural question, but I think the crux of our argument is in 2 and 3, is that information should never have come before the court. Anything that happened prior to the child's birth or prior to the last custody order is irrelevant. And in this case, it was prejudicial. And it wasn't as if the court just completely ignored it. The trial court actually, and the magistrate also put in their decisions, specifically both parents testified that this happened, which was not true. And it is a best interest factor, so even putting aside whether it was in the F2 factors, it is a best interest factor. We don't know if the court considered that in giving dad equal time. I mean, we'll never know that. It wasn't specifically in there.
But don't we have to know that to determine prejudice?
Well, I think you can infer that because there was a specific finding about it. So the court obviously took that information into consideration in its decision because it made a specific finding that there was domestic violence when it didn't occur. And again, it should never have been put into evidence for any reason, and there was an objection to that basis.
I believe there's an assertion that the basis of that additional testimony was to explain father's reluctance to engage with mother.
If that were true, and I don't know if that was the specific argument or not, if that were true, then he would not testify about the abuse towards their son. And that's what he said, that mother was abusive to their son. But then he said, I never saw it, never did anything about it, never talked to her about it, never called Children's Services. Again, these were all, in my client's opinion, false allegations. She specifically refuted them. It was just a way that she thinks was to get back at her or punish her, to make her look like a bad parent, even though he only wanted at the most equal parenting time, which again, it does not make any sense. But regardless, it should not have been permitted. I want to go back to quickly on the equal parenting time schedule before my time is up. Mr. Sims talked about father requesting holiday time, but father was not exercising that holiday time. Even though he asked for it, he specifically said, I did not exercise my holiday time. So even though he had the ability to do that and to be more involved, he chose not to do that, and he made that conscious decision. Also, he had been in Cincinnati, or in the Cincinnati area, since 2022. This case did not end until 2025.
Is Athens a Cincinnati area?
No,
Your
sir.
definition?
He was in Athens from 2019 to 2022.
Mm-hmm.
He moved to Cincinnati, the Cincinnati area, in fall of 2022. And again, while the case pended for 2 years, he had the ability to be more involved, do the things, and he chose not to.
Did he provide any reason why he wasn't participating?
What I found in the record is he said that, for example, activities and things just didn't fit his schedule. So it was because he was not making the child a priority, which is what the GAL said. And even though there was a step up in her report, she testified very clearly at trial, I don't think that equal time is in the best interest of this child because father has not prioritized the child, has not taken advantage and done all the things to be a good co-parent. So she did not recommend that.
Well, that was in the initial recommendation, right? And then over time, it changed.
Correct. So I have nothing further. We ask that the court sustain our our assignments of error. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision.
Thank you.
All right, the final case on our docket this morning is C-240655, Kelly versus Forest Holdco. Would you like to reserve time for rebuttal?
Yes, Your Honor, 5 minutes.
All right. You may proceed when you're ready.
Okay. May it please the court, I think as the court's aware, there's 2 issues on appeal. There were 3 assignments of error. 1 assignment of error was struck before this hearing. But the 2 assignments of error are one that relates to the proper measure of damages, and the second one was the incorrect journal of what occurred at the trial. So the first one as to the damages, it's a de novo review, whether the proper measure of damages was employed by the court. As to these trees that were cut down back in 2017, the testimony was unequivocal. Mr. Kelly testified that the value that he placed on the trees was what it would cost to cut them down. However, that's not a proper measure of damage for this type of case where there's a trespass that involves cutting down trees. The precedent is supplied by this court from 40 years ago in the Denoyer case, and it said you can either get the diminution in property value. In this case, there was no testimony as diminution of property value, stumpage value, which is something that is used for commercial purposes, that based off of the size of the tree, the type of the tree, the board feet that can be procured from the tree, and what the present value is for that board feet, that testimony was not presented either. The third one is replacement cost or restoration cost. And again, there was no presentation of evidence by the plaintiff.
Well, doesn't that imply, I mean, to restore the trees, to bring the property back to its foliage state, would require tearing down or cutting down these damaged trees to put back up new ones?
Then-
Or could the trial court reach that conclusion?
I don't believe so. The trial court is basically establishing a fourth set of damages, which is the cost to cut down trees, which was presented in this Seattle land case that the Kellys cited in their brief. And in that case, the cost to remove trees was denied by the trial court in that case, and it wasn't addressed on appeal. But it's not a proper measure of damages. You have to present evidence as to what the cost is to purchase a new tree and cost to plant it. Usually you have to do this through an expert, an arborist. Again, none of that was done in this case.
So is it your position the trial court should have just denied tree damages outright?
Correct. I mean, there wasn't sufficient evidence.
Isn't there case law that suggests in a residential piece of property that when there's been damage to trees or other kind of landscaping, that the homeowner can place sentimental value, that they can describe that, you know, this is like a buffer when I look out my kitchen window, I want privacy protection and that sort of thing, and place a monetary value on it?
That is when, if you look at the case law, that's when the alleged value exceeds the diminution in value, because almost all damages cases is what's the value of the property beforehand and what's the value of the property after the alleged tort. In some of these cases, if you're dealing with, and this is where they get this exception, to allow you to argue that the replacement cost or the restoration cost exceeds that diminution in value, because that's the traditional tort principle.
And why wouldn't this kind of testimony, broadly construed, fall into that kind of category when you have a homeowner saying, it's going to cost me this much, you know, I live here, like, why couldn't the trial court put it into that category?
I mean, the trial court could if the evidence was presented. I mean, there's just no evidence of this is what's going to cost us to restore our property to the condition prior to the alleged conduct occurring. So
because that evidence wasn't presented, your client is able to cut down trees on someone else's property without paying for it?
No.
So how was that damage cured?
You present the evidence. I mean, the defendant is not the master of the plaintiff's case here. The plaintiff had the ability to present that evidence.
So is this $5,000 per tree that was just completely made out of whole cloth?
It was. If you, I mean, the two plaintiffs were testified. The first one says, I don't know as to what the value of the trees was. That was her testimony. Second plaintiff, Mr. Kelly, said basically the same thing, and then he was led to say, well, I know that it cost $5,000 to cut down a tree.
So there was some testimony that it cost $5,000 to cut down a tree.
To cut down a tree.
Did your client present any testimony to refute that?
I don't think my client needed to present any evidence if they're not presenting the right type of evidence to support the damages that they're seeking.
Well, there was evidence that's $5,000 per tree to get it cut down.
Correct.
Okay. And your client didn't present any evidence
I don't think,
Contradict that.
I mean, why would my client volunteer?
My
with-
question simply, did he or
They
did
did
he
not, no.
And with respect to the other aspect of damages, the emotional distress, at any time, did the homeowners ask your client not to trespass on their property?
There was testimony in the case.
And what was your client's response to those requests?
I think they had an issue where they could not meet up to discuss a mutual understanding. But if you look at, as you talk about the emotional stress, if you look at what Judge Lubers did, she did not say that she was awarding any damages for emotional distress in this case when she rendered her decision at the conclusion of the bench trial.
Is there any case law that requires the ultimate judgment entry to match the verdict that's pronounced in court in terms of those damages?
I believe the Dowling case that we cited, it says that all litigants have the right to have the proceedings correctly journalized, and that simply wasn't done. That's been case law since 1990, came out of, this area. She did not make an award of emotional distress. It was very clear.
What about the line of case law that your opponent has cited that a court speaks through its written entries and not through its transcript? How do we reconcile those two things?
I think that's where the Dowling case that we cited, the Supreme Court decision from 1990, clearly had the same issue, where it was a little bit different, where the person that was challenging was seeking a writ, but there was issues where the statements made in open court did not match what was in the entry that followed. And so that's why they challenged it, and they were successful in their challenge. And that's the same thing that we're doing here. There just was no award of emotional distress made by the trial court.
Let me go back to that emotional distress. I have a note here that Mrs. Kelly, who I assume confronted your client about the trespass, was left to feel degraded and frustrated. Was there evidence in the record to support her feelings of being degraded and frustrated from that encounter?
I'll admit that she had that testimony.
No, my question was there testimony to support those feelings? How did your client respond to her request to stop that would lead to her feeling degraded
I think that's where
and
they
frustrated?
that's where they were going to have the conversations between the member of Forrest Holdco and Mr. Kelly, which they exchanged text messages, and they never had an opportunity to meet up with each other to discuss it.
Were any of the agents of your client, did they provide any testimony, or was there any testimony about the conversations with Mrs. Kelly?
I believe there was some testimony given by one of the workers.
And I guess I'm stressing this because this being left degraded and frustrated, it seems like there would be more than just a casual conversation. And I just want to understand from the record, what was your client's response to Mrs. Kelly asking them not to trespass on their property?
I think the response was that they were, I think, again, this whole case, I think, originated from a misunderstanding of the property line and a retaining wall that had caused there to be debris and dirt and other trash that covered up a parking lot that was behind the apartment building that my client had recently purchased and was renovating. And that's where the disagreement came up as to how far did the line go in the work that was done in that area.
No, but I understand that. My question was more specific in terms of that encounter with Mrs. Kelly.
I think it was, my understanding was it was a singular event.
Okay. In that singular event, what about that encounter left Mrs. Kelly degraded and frustrated?
My client can't testify to that. They don't know what, that's her feelings.
And you're saying there was no basis for her to walk away from that encounter with those feelings?
She has the right to have those feelings. I'm not challenging that issue on appeal. I think the appeal is that the court.
You're challenging the emotional distress damage.
Right, because the Judge Lubers did not make that award.
Okay, it was in the entry.
Yes, and this is why that's the third assignment of error, that the entry incorrectly recited what her decision was.
And
In
doesn't
open
the
court.
court speak through its entry?
Right, and this is where the court has to correctly speak through its entry, and that's what the Donlin case talks about. It's an abuse of discretion if the entry does not match what was stated in open court.
Can the court change their mind?
I don't believe so. I mean, the court clearly, if you look at the last several pages of the record here, the court clearly.
And I'm going to
did not-
rephrase that question. Can the court change their mind if the evidentiary record still supports the award that's journalized in the entry?
I don't believe it can. I haven't seen any case law that says they can go back and grant damages that it explicitly decided not to award. And there's been no case law cited by the appellee that says that it could.
There's one thing that you did not address in your arguments, which was the 2017 case.
That's
Can
what,
you address that briefly?
well, we had made reference to the 2017 case. We filed a request for judicial notice of the dismissal of that case, and a merits panel denied that motion and basically said that that argument would not be considered even under a plain error standard of review. But in the 2017 case, that case was dismissed in 2023 for a lack of prosecution, which is a
But
40.
ultimately, it never was brought in as part of the record. Is that right?
Correct. There was reference to it by appellee's counsel at the trial level. The claim, I mean, the argument was res judicata and/or statute of limitations would have clearly applied at that point in time. But those arguments were struck, my understanding was struck by this
Right.
court.
Was it raised at the trial court? Those defenses, were they raised?
They were not, other than plaintiff's counsel saying that the case had been filed and dismissed and then refiled.
And is that a waiver problem?
That's where our argument in the first assignment was that the plain error can supersede a waiver issue at times. And we cited a couple cases where arguments were not made at the trial court level, but on the Court of Appeals, that they addressed those issues and decided to reverse based on.
Yeah, and you're aware that plain error review is a very, very high standard for a civil proceeding, okay? I found some case law that indicated that when it could have been easily raised, the issue that plain error review should not even be applied. So if we were to apply that, how would you pull it out of the it could have been easily? In other words, why couldn't have been it easily presented at the trial court level?
I mean, that's where, if the court's not going to accept judicial notice of the prior case, which was with the decision.
Yeah, the problem is that judicial notice brings us back to res judicata. So if it's, that's, to your waiver, I'm sorry, to the fact that it wasn't raised at all. And by it not being raised, and since it doesn't challenge subject matter jurisdiction, res judicata does not, right? So it's not a void issue, it's a voidable issue. And since you didn't raise it and it's voidable, then it's waived, and then brings us back to the plain error. So
Correct.
the judicial notice doesn't help because of the posture that it's not void, it's voidable.
I don't disagree with you as to your analysis. But we did cite a couple cases in our brief where arguments that were not made during the course of a trial level were considered on appeal, and matters were reversed because of that. One was, I think, that came out of this court system on a Consumer Sales Practices Act case. So that's why that argument was raised. It's up to you as to whether it's a prevailing argument. But, it clearly, especially in our system, where the case was dismissed in March of 2023, if the appellees felt that that was an improper dismissal, they had the right to appeal at that time. They chose not to. They chose to refile a new case. They chose to not notify the clerk that this had been a refiled case, which then it would have been reassigned back to signed back to the trial court judge who had just made the decision to dismiss it, and I think that's what caused this case to go down a wrong, contributed for this case going down the path that it did.
And counsel, you're out of time.
Thank you.
Thank you.
Good morning, Your Honors. Steve Davis on behalf of Bobby and Denise Kelly, who are here in the courtroom with us. I'll start with what I think we're not disagreeing about. We have a $411,000+ judgment, and we're not fighting over $275,000 that Justin Emlin testified would be the cost to restore the hillside. We're not testifying about we're not arguing about the $50,000 punitive damage award. We're not arguing about the attorney's fee component that was attached
Do you
to it.
mind raising your voice just a little bit?
I'm sorry. Gosh, you might be the first person to ever tell me.
I know, and I used raising your voice as if I'm asking you to, clearly I'm not asking you to shout or anything.
That's amazing. Anyway, we are here to talk about the value of trees, and we are here to talk about emotional distress. Let's talk about the value of trees, because I think one of the things that makes this a confusing issue is we're talking about two different sets of trees. And I'm not sure how clear that is in the record or in the briefs, but in 2017, with bulldozers entering onto my client's property, they tore down a bunch of trees. And that's one set of trees.
And are those trees reflected in the $275,000?
Yes. And therein is part of the problem. Well, let me just say this. I'll say yes. I'll say yes because it's unclear, but I'm willing to concede it. I do think you could read it and maybe argue, because of the testimony, that it's not certain that it's included. But for purposes of this argument, I'll concede that it's in there, which is one of the reasons why the oral pronouncement of the judge was a little odd, because she talks about both sets of trees. Let's talk about the way what I think makes this appeal more easily understood. So bulldozers come over and tear down a bunch of trees. Justin Emlin, our expert, testified at trial, here's what it's going to cost to restore the hillside. And he said $275,000. And what's that going to entail? Well, we're going to have to regrade the land. Okay. In regrading the land, what are you going to have to do? And he said, well, we're going to have to, among other things, take down some trees. And so there's that I do believe fairly is part of the $275,000. The question, I think, ultimately is, are the Kellys entitled to restoration of the land for $275,000 and the value of the trees that were initially removed 6 years earlier by the bulldozers operated by the defendant? Mr. Kelly, and I think Judge Kinsley, you recognized that the body of case law that says that a property owner is competent to testify as to the value of his own property, and that extends to things like trees. Is he competent to testify about what it costs to remove them? And I'm not sure he is, which is one of the reasons why I didn't ask him to. He's not in that business. He can put a value on a tree, but he doesn't know the cost necessarily to mobilize equipment and remove trees. He also didn't testify as to the value to plant trees. There's two reasons for that. He's not competent to do it for the same reason, and the testimony in this case is those trees can't be replaced. They were 60-foot tall trees. So there isn't a cost associated with planting those trees. There is only the value of the trees. It was said that there's nothing in the record that talks about the value of the trees. There's only the value of what it costs to take down a tree. That's not true. I mean, I quoted in my brief. Can you give me an estimate on approximately how many trees were removed from the backyard? And the answer is, he's counting from a photograph, 1, 2, 3, 4, 5, there's at least 7 to 8 trees. And then I asked the question, and your opportunity to give an owner's value of those trees to the judge. And he says, well, I'd say $5,000 at 8 trees. That's $40,000 when you calculate it. So it's very clear.
What does owner's value mean?
It means, as an owner, this is the value I assign to it, which he's competent to do. You know, he's not an arborist. Could we have called an arborist? Of course. But knowing that he's competent to testify as to the value of his own property, I elected not to do that.
Isn't there case law that speaks to the emotional value, the enjoyment value that a homeowner would place on this kind of foliage, but then also recognizing the gap that you're describing for 60-year-old trees? You can't just find another 60-year-old tree and replace it on the land. You have to replant a much younger tree, and it's going to take a lot longer for the trees to grow. And therefore, a homeowner is entitled to compensation for the period of time where they used to have this filled-in, beautiful, lush yard, and now they have a much different yard.
And that's exactly what's in the record. That testimony came primarily from Danessa Kelly. And Danessa Kelly talked about the value that she put on the trees in terms of their not only aesthetics, but her feeling of protection and security and privacy.
That's what I'm trying to understand, this owner's value. Was the owner's value simply like an arborist assessment of the value of the tree, or is it more than that when you ask that question?
Well, I'd be reading into the answer to tell you whether or not, when Mr. Kelly says, I'd say a tree is worth $5,000, we didn't do a deep dive as to, you know, is it $5,000 because of the security you feel from it? Is it $5,000 because of its size and its composition? Is it $5,000 because of its aesthetics? I just said, what's the value of a tree? And he said $5,000.
And Holdco didn't present any evidence to refute that
No.
estimate?
No.
And did they object to
No.
him placing a value
No.
on competence or something?
I don't recall that they did. I don't recall that they did.
Counsel, can I turn your attention to this emotional distress?
Yes.
And I was trying to get to what that exchange was between Mrs. Kelly and the representative from Forest Holdco, because I understand that it was a single incident. Was there any evidence as to what transpired during that incident that caused Mrs. Kelly such distress?
Well, let me suggest to you that the premise of your question doesn't match the record, although it does match what Mr. Vandelon said. This was not a single incident. And if you look at the record and read the transcript, you'll see that one of the things that led to Ms. Kelly's frustration is, I saw bulldozers on my property. I went out and told them that you're on my property, please get off. She went back into her house, and they continued doing what they were doing. There were multiple occasions where she confronted the people on the bulldozer and told them to leave. That's why punitive damages were awarded here, is because they ignored her. And if you look at the record, one of the things she said is, you know, it was extremely frustrating because I confronted them over and over and over again, and they just pretended like I wasn't there. I felt demeaned, I felt ignored. I'm not sure if it's because I'm black, I'm not sure if it's because I'm a woman. I don't care, I don't know why it was, but they were treating me as if I didn't exist.
While they were on her property?
While they were on her property. Day after day after day. So that's what the record evidence shows, and that's what was before the trial court. So I think that's what caused her blood to boil, is why aren't they listening to me? This is my property, and I've told you repeatedly to get off my property, and you just won't do it.
And did they have any explanation at trial as to why they ignored this property's owner's
Not
needs?
really. I mean, not beyond the implication, I think, that they believed they weren't on her property. But that flew in the face of, well, you know that there are two lots between your lot and my residence. There's my residence, a lot, another lot, and then their apartment. They were across the first lot, across the second lot, and into their residence lot. That's how far they came. So for them to say, well, we thought we were on our property, and then I asked them, well, what about the stakes that were along the property line? And I think the testimony was kind of, what stakes? Well, did you do a survey before you sent your bulldozers onto the property? No. Could you have? Yes. You know, as a developer, that doing a survey is part of what you ought to do if you're rehabbing a piece of property. Yes, I knew that. Why didn't you? And the answer was almost like, I took my chances.
But they didn't have this exchange with Mrs. Kelly.
No, not that, not that.
And
But
I want to
there were
get back to the ignoring. Did they literally ignore her while she stood there, and did bulldozers continue to bulldoze?
If by ignore you mean, did they just keep working despite what she was saying? The answer to that is no.
Okay.
She would confront a bulldozer operator and want to have a discussion, and they would stop their bulldozer, get off it, come to her. There would be an exchange. You're on my property. I don't want you on my property. Get off my property. And I'm not, the testimony's a little unclear as to exactly what they said to that request, but she would go back into her house, and then an hour later, she'd hear bulldozers again. And she'd come back out, and they'd be right where they were, picking up doing exactly what they were doing before. And she would flag them over, the same conversation would occur. She'd go back into her house, and I don't know, it didn't all occur on a single day. Like the next day or the day after that, the same conversation. And then the next day or the day after that, same conversation. We didn't really pin down because her memory wasn't such that, you know, on 10 a.m. on this day we had a conversation, and then at 10:30 we had a conversation, and then, but she did testify over multiple conversations, some multiple in a single day, some over multiple days. They just continued to do what they were going to do. And their testimony was, which I think particularly Ms. Kelly found particularly frustrating, was an attitude of, and this is in the record, ma'am, we're doing you a favor. She said, you're not doing me a favor, sir. You know, this is my land. You may think you're doing me a favor by grading this area. I want you off my property. But it was the attitude of, get out of my way, I'm doing you a favor.
And I want to be clear, was that, I'm doing you a favor, a statement that was actually made, or was that what she took away from?
That was a statement that was actually made, and she quoted it. And by the way, she kept a diary. The diary was admitted into evidence, and that's in there. Her statement of the conversation with the quotation, ma'am, I'm doing you a favor, was in the record.
I'm now confused because counsel for Forrest Holcomb was certain that there was a singular exchange, there was a singular confrontation between Ms. Kelly. And you're saying that there was documented evidence, including a diary, documenting that there were multiple conversations over multiple days. So how are those two facts confused?
You need not be confused. The record is very clear. There were multiple occasions. I will give Mr. Vanderlaan the benefit of the doubt that he wasn't trial counsel. I can't explain why he would represent to this court there was one occasion. The record is very clear. There were multiple occasions. Brian Lewerk, who was trial counsel, I won't tell you what he would say if he were here, but there were, and the record supports it.
Can you address the inconsistency between the trial court's oral ruling and its judgment entry?
Yes, I'll start with Judge Ayes's comment. Isn't a trial judge allowed to change her mind? And I think the answer to that is yes. And I can just simply tell you, as a trial attorney, I've seen it happen where I've had a judge tell me from the bench, here's what I'm going to do. And then I've gotten a decision back that didn't seem at all like that's what the judge said they were going to do. So does it happen? Yes. Can it happen? Yes. Is it legal for it to happen? Yes. Now let's talk about what happened. What happened was, although I'm kind of feel like I'm invited to tell you a story that I'm not sure is supported by the record. So let me confess that up front. And if any time you want to say, counsel, is that in the record, feel free to do that. But I have to kind of...
Well, it would be most helpful for us to hear what is in the record.
Sure. What's in the record is the testimony, or not the testimony, the oral decision of the judge, and I'll also confess and concede to the court that when the judge is saying $30,000 for this, $275,000 for this, $35,000 for this, $50,000, she doesn't mention emotional distress in her line item breakdown. What she does say is, I'm awarding $390,000. That's very clear. And I'm putting them in these subcategories of these amounts of money.
So is your point there that even if there was a mistake, there's no prejudice?
Correct. That's part of my argument, is it's very clear that she wanted to award a certain amount of money in certain categories, and that's what the judgment matches. So, am I going to call it no harm, no foul? I don't know. But I will say this. In her oral pronouncement, she does talk about the egregiousness of the conduct of Forrest Holdco in these multiple exchanges and the mental effect that it had on my clients. So it's in the record. It's an available item of damage. She recognized that it was an available item of damage and that it was within her purview to award it.
If it was a scrivener's error, what would have been the proper vehicle for the appellant to address that?
Well, I think it would be for the defendant's counsel to ask the judge to revisit, to a motion for, it's not really reconsideration, but yeah, that kind of a vehicle
Or
to
to
correct.
recorrect, yeah.
Right. Now, here's what I'll
And
say.
that would have been a motion that would have been filed directly with the trial court, not
Correct.
with us.
Correct, and that sort of motion is filed all the time. The other thing that I'll say is, the court's aware that, well, here's where I also fall on the sword a little bit. You'll see from the transcript, the judge directed me to present an order to the court. So the order that was signed was an order that I prepared, let's be clear. I have to concede that, so I'm part of the problem here. But part of the challenge was that, well, and also know, though, that the order, because I'm required to by rule, I submitted it to opposing counsel ahead of time and said, hey, look at this. I'm going to submit it to the court. Here's what it says. Do you have any objection? And I got back a no. And then when it was submitted to the trial court, it was submitted with a cover letter.
Is this the off-the-record story that you wanted to tell us?
Yeah, I mean, it was seen and approved by opposing counsel, and then it was submitted to the court with a copy to counsel. Why did the problem happen? The problem happened for two reasons, I think. Number one is Judge Lubers announced her decision from the bench, which in my experience is a little unusual immediately following testimony. The typical experience that I've had anyway is that a judge takes it under advisement and issues a written decision. She didn't. And in her discussions, she mentioned trees twice. And that caused me a little puzzlement, as well as opposing counsel, particularly since I'm confessing that the value of the trees that are yet to be removed was already in the $275,000 figure. So I've got a judgment that says trees twice that I took to mean a mistake because we had already counted the trees here, and now we're counting them twice again. And I'm looking through my notes, and we don't have a transcript yet. I'm not even sure, but I won't commit to you. that
Counsel,
opposing
you have
counsel-
about 30 seconds
Okay.
left if you want to.
And, yeah, my last comment, I'm not even sure I didn't have a telephone call with opposing counsel, like, I'm puzzled by this, but here's what I'm gonna do. And I did it. So
Yeah.
that's
I guess
kind of
I'm
what-
wondering if it's waived because the proper vehicle would have been to file with the trial court
Yes,
for correction. I'm just wondering.
yeah, if it was a mistake, I mean, not only had they approved it, but they could have certainly done what you're suggesting.
Thank you.
Thank you, Your Honors.
Can you start off where I ended, please?
That a post-trial motion should have been filed as to the issue, as to the judgment entry.
Yeah, to correct the judgment entry.
I mean, I think in a
To put-
perfect world, that's possible, but, when you have to make an order to the clerk's office to get a transcript so that you can review the transcript to see what's going on.
But wouldn't the trial attorney the trial attorney was there. The trial attorney heard the pronouncement. The trial attorney received the judgment entry. The trial attorney, if there was a deviation, would be apprised. So putting aside the idea that the entry was vetted through the
Then I-
trial attorney, but through the trial attorney, putting that aside,
Then I think it goes back to something we discussed earlier about the plein air review as to this. The Dahlan case that we cited says it's an abuse of discretion by the trial court judge to make an entry that's inconsistent with the oral pronouncement during the course of the proceedings. I have no explanation as to why there was a confusion when the entry was being drafted, but it clearly, Judge Luber's pronouncement only lasted several pages at the very end of the transcript. She made no reference to emotional distress damages, didn't even hint at awarding it. So then it becomes, I think it does become very problematic, as Mr. Davis said, that the attorneys were the ones that drafted this entry. So I'm not blaming Judge Lubers for, drafting it and having an incorrect statement in it, but, trial counsel didn't provide her with a correct entry. which I think is problematic.
Well, that's on both sides, right?
Correct.
And is there an issue with invited error under these circumstances?
You know, I think there would be invited error if counsel affirmatively for Forest Holcomb said, I believe you're wrong here, I believe she awarded a $30,000 in emotional distress damages, and that was then added to the entry and then provided to the court. Again, there's
Was there
nothing in the
any
record.
testimony to support, so the trial court in its oral pronouncement awarded $35,000 to cut down the trees and then $30,000 to plant new ones, right?
No. There was testimony regarding trees that had been cut down.
Oh, it was two different categories of
And then-
trees?
And then Mr. Kelly testified, well, I'm concerned that I may have to remove trees on a going-forward basis because they could fall onto Forest Holdco's property. And I estimate that there are another 5 or 6 trees that may fall into that category.
All right, so there was some testimony in the record as to, and I understand that the sides might see that testimony and its meaning differently, but there was some testimony as to the $30,000 that the trial court orally awarded.
Correct. The whole, the $35,000 for 7 trees and then the extra 30 for 6 trees, they all related to trees.
All right.
If that makes it easier.
Yes, thank you.
So there was, I guess, 13 trees being considered when she made her decision. 7 in the past and 6 potentially in the future. And again, I think this is where, you know, our primary argument is if you just look at the Denoyer decision, the case law that comes out of it, it's basically the case law in the state. There is no, if they don't present diminution in value type evidence, and they conceded that in their brief, they conceded it today, they cannot, they're trying to get a 4th category of value to the owner and not restoration costs or restoration damages. There are only 3 categories that this state allows for damages in these type of situations. And I think that's where some of the question, I think, got a little far afield because even in their Seattle land case that they cited, it says restoration costs may be recovered in excess of diminution fair market value when real estate is held for non-commercial uses, which you're talking about when it's held for personal or residential use. When there are reasons personal to the owner for seeking restoration, when the diminution fair market value does not adequately compensate the owner for the harm done. But that it keeps on talking about restoration and not what is the cost of restoration. And again, you know, I'm not asking you to review the entire record, but the citations made to you in the briefs shows that there was no evidence of restoration cost or restoration damages at trial.
What about the testimony of Mr. Kelly?
That it cost $5,000 to cut down a tree?
No, well, according to Lisa's counsel, that it was, he estimated the damages that they suffered as a result of the trespass was $5,000 per tree.
And his whole, you know, his owner testimony, it was based off of what it cost to cut down a tree. That it's all premised off of that.
Whatever it's premised on, the owner testified that he gave an evaluation of $5,000 per tree.
And I believe that would be an improper valuation based on the Francis case cited by Appleese in their brief, where an owner in that case said, well, I think the tree is worth this, and there was no other evidence to support that. I mean, they didn't do a comparison as to, I mean, again, the record has no information as to the type of tree, size of tree, anything like that.
But can't the owner just say, I like this tree, this is my favorite tree, I love this tree, and I think it's worth $5,000 to me personally?
I think that evidence is insufficient in the context of this case.
Counsel, you're out of time.
Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Enjoy the rest of your day.
Thank you.